It begins with a crime that feels like something out of a holiday nightmare. Just days before Christmas, a woman breaks into her neighbors' homes, stealing their sense of security along with their belongings. The defendant, Megan Wilhite, stands before the court charged with burglary of a habitation, a second-degree felony that carries a potential 20-year prison sentence. Pleading no contest, she hopes for mercy, blaming a bad state of mind and the influence of another person for her actions. But this judge isn't interested in easy excuses. What follows is a masterful takedown of the defendant's narrative, revealing a calculated crime, not a simple mistake. The judge will issue one of the strictest probations imaginable, a final chance at redemption. But the story doesn't end there. In a stunning turn of events, this defendant will be back in the same courtroom, facing the same judge, forcing a final dramatic confrontation.
For the defense?
Gail Caldwell here from Megan Wilhite.
All right, and probation, this is a probation case? All right, and are you Megan Wilhite?
Yes, Your Honor.
Ms. Wilhite, I'm gonna show you what's entitled Court Admonishments, Waivers, and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of burglary of a habitation force? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your
Counselor, has your client been able to provide you with any defenses to this offense?
Honor. Yes, Your Honor.
Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. There are no applications for deferred adjudication. State recommends community supervision. They're taking in consideration grand jury number 767380, which is CM number 93783. County Court cause numbers 614-877, 671768. So restitution is to be payable to the following: Paul Gould, that's Gould, Ricardo.
Listen to that list. Paul, Ricardo, Alejandra, Isabel, Jesse, Megan, Frank, Joy, Lana, Savannah, Robert, Marina. This isn't just one victim. This is a list of over a dozen people whose lives were violated. The sheer number of names being read into the record paints a devastating picture. This wasn't a single impulsive act of desperation. It was a spree. The court is making it crystal clear that the defendant's actions caused a ripple effect of harm throughout her own community. The judge's order for no contact is more than just a legal formality. It's a barrier erected to protect these families from the person who shattered their peace. Wilhite didn't just steal from strangers. She victimized the very people she lived alongside, betraying the fundamental trust that holds a neighborhood together.
The letter A, Salceda Rebollar, Rebollar. And I'm sure those L's are supposed to be pronounced with the Y.
I was never good at that in Spanish class.
Alejandra Perez, Isabel Gomez, Jesse Weathersby, Megan Morris, Frank Washburn, Joy Robertson, Lana Shadburn, Savannah Shadburn, Robert Shadburn, Marina Frenia, Frinea, and there's to be no contact with either of those parties mentioned. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement.
Yes.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 5 years. There'll be a TAP evaluation and 200 hours of community service restitution in CATs 1 and 2. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Your Honor, the state moves to admit what's been marked.
This is the moment the judge completely dismantles the defendant's entire defense. Wilhite tries to paint herself as a victim of circumstance, someone who wasn't in a good state of mind, but the judge immediately cuts through the excuse with cold, hard facts. You don't accidentally find a cinder block, you don't accidentally climb through a window, and you certainly don't accidentally make sure to leave no fingerprints. These are the actions of a calculated burglar, not someone who simply made a poor choice. The judge is exposing the glaring contradiction in her story, claiming to have a clouded mind while simultaneously carrying out a methodical crime. It's a powerful reality check, forcing the defendant to confront the deliberateness of her actions and stripping away any sympathy she hoped to gain.
The state's exhibit 1 into evidence.
No objection.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor, I think my client wants to make a change in her life, and she has a mother at home that just had a grandma, has seizures, and she also has a 17-year-old. My daughter is 14 weeks pregnant right now. She's 14 months pregnant. 14 weeks. She wants to get out of jail, and she's willing to comply.
But she's not a good role model for her daughter. And she's not a person who should be allowed to take care of anybody, let alone a goldfish. Because she has, you want to explain to me why you're breaking into people's homes when they're away?
Your
You
Honor,
ruined somebody's Christmas because this occurred December 17th, Christmas just days away.
Your Honor, I was not in a good state of mind at that period in my life, and I was under the influence of an individual who had a really bad hold of me. I made very, very poor choices, and I'm willing to.
No, I mean, you actually, people are saying, always say, you know, I was in good frame of mind. I understand that. But your frame of mind was good enough to get a cinder block, climb through a window, go into somebody's home, and make sure you don't leave fingerprints. So I don't understand what you don't understand, that stealing's not right.
I am aware that it's not correct, Your Honor, and like I said, I've made a very poor choice, and I just want to be able to have a second chance to make this right. And
It can't be made right. Let me just tell you why it can't be made right. Because I'm sure all of this stuff that you took, that person's not gonna get it back. And if they get it back, it's not gonna be the same because somebody else has been using it and somebody else took it. Just like their home is never gonna be the same. You know why it's not gonna be the same? Because somebody entered their home without their permission. And Christmas is never gonna be the same. You know why Christmas is never gonna be the same for them? Because December 17th, somebody broke into their home while they were away. So you can't make it right. Sometimes things that we do, you can't make it right unless you can go back in a time machine and not do it. So who are you living with? I mean, one of the worst things, and it's not even really the worst thing, but one of the odd things is you live in the neighborhood. People saw you on the video, they're like, oh, I know her. She lives right in the
I no
neighborhood.
longer live at that residence, Your Honor.
As you should.
No, I've not lived there for quite a while. I live in Cibolo.
When's the last time you had employment?
Before I was arrested, I was employed with Southern Wildlife Rehab Facility.
Doing what?
I work with animals, Your Honor.
And is she planning on staying in Bear County?
Yes, Your Honor.
With who?
With where I was living at, my best friend and I have a place in Cibolo, 213 Bridge Crossing in Cibolo.
Okay, so you're gonna be living in Cibolo, Texas?
Yes, Your Honor.
All right, so that's not San Antonio. Am I wrong with that?
I think parts of it are in San Antonio, Your Honor, or
Are you-
in Bear.
No, I'm just talking about
Oh,
this.
San Antonio, Bear. Sorry.
Yes. All right. Do you have any mental health diagnosis?
No, Your Honor.
Do you have any drug issues?
No, Your Honor.
Then I don't understand this wrong frame of mind. Counsel, help me.
I don't, there's that she's willing to accept responsibility for her conduct. I can't explain that.
All right, as previously stated, the court is finding you guilty. I'm not even gonna say it. Okay. So here's the things. The court is gonna sentence you to 10 years in prison, suspended and probated for 6 years. There's a $1,500 fine, time and money to run concurrent. There is to be taken in consideration grand jury number 7673.
The judge isn't just handing down a sentence, she's crafting a behavioral cage. The terms of this 6-year probation are incredibly specific and severe. 2 field visits per month, no unsupervised contact with any minors, and no jobs as a caregiver. She even denies the defendant the standard 40-hour community service credit for a COVID vaccine, a small but significant detail showing just how little leeway she's willing to give. The judge is essentially putting Wilhite on the shortest leash possible. The parenting classes are offered as a potential path to earn back a small amount of credit, but it's framed as a challenge, not a gift. This sentence sends a clear message: you claim you want to change. Prove it. The judge has built a gauntlet of rules, and any misstep will have immediate and severe consequences.
80, which is also CM number 937838. County Court cause numbers.
That was her one last chance, an incredibly strict probation designed to force her onto the straight and narrow. So did she take it? We now jump forward in time, and Megan Wilhite is back in the exact same courtroom, standing before the exact same judge. But this time, the charge isn't about a new crime. It's about squandering the opportunity she was given. The court is hearing a motion to revoke her community supervision. She has failed. The question is no longer about whether she deserves a second chance, but about the consequences for throwing it away. The facade is about to crumble as the court dives into exactly how she violated the judge's trust, revealing a pattern of excuses that is finally worn thin.
614-877-671-768. There's to be restitution and no contact with Paul Gould and Robert Shadburn, Shadburn. There's to be no unsupervised contact with minors. There's to be proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. I'm going to want the UA hotline until further notice. There's to be regular reporting by Zoom or in person. I'm going to want field visits 2 times per month. We can do that for 6 months to see how she's doing. 200 hours of community service restitution. And usually I give people 40 hours of credit if they receive the COVID vaccination, but I'm not doing that for you. So it's 200 hours of community service restitution. We're going to do CATs 1 and 2. And usually I give people my own CATs 1 and 2, but I think you need the extra help of CATs 1 and 2, other than me telling you, don't steal, don't take what doesn't belong to you, don't go into homes unless you're invited. If you are invited.
Here we have a dramatic shift in her defense. Faced with the revocation of her probation, Megan Wilhite now reveals a crucial piece of information she conveniently left out during her initial sentencing, a 6-year addiction to methamphetamines. Her new plea is for help, asking the judge to send her to Safe P, a substance abuse treatment program, instead of prison. On the surface, it appears to be a moment of raw honesty, a cry for help from someone who has hit rock bottom. But the timing is incredibly suspect. Why is this coming up now, only when she's facing prison time? Is this a genuine desire to get clean, or is it one last desperate attempt to avoid the consequences of her actions? The prosecution is about to probe that very question.
And you're told to leave, you leave. Don't accept an invitation to somebody's home from a third party. But you need more than that. I'm going to have you do parenting classes because you're telling me, well, you're making me think that you're going to be involved in your daughter's life and helping her out with your grandchild. I don't know if that's true or not, but I'm already saying no unsupervised contact with minors. But I'll give you parenting classes, and I'll tell you what, if you complete parenting classes, I'll deduct 40 hours of community service restitution. All right, is there anything else from either side with regards to sentencing?
No, Your Honor.
All right, we can go off the record. Good luck to you. You're gonna have to do better in life. I mean, some people find you in their homes without their permission. It doesn't end well. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
Thank you. It's always good seeing you.
Thank you.
Yes, ma'am.
All right, the court is calling 2020 CR 2272, State of Texas versus Megan Hayes Wilhite. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Kelly Piddle.
And are you Megan Wilhite?
Yes, ma'am.
Am I pronouncing your last name correctly?
Yes, ma'am. Wilhite.
All right. I'm going to show you what's entitled Motion to Revoke Community Supervision and First Amendment Motion to Revoke Community Supervision. Did you review those documents with your attorney? Did
Yes,
you
ma'am.
understand them?
Yes, ma'am.
Are you the same Megan Hayes Wilhite who was placed on community supervision in 2020 CR 2272 for the offense of burglary of a habitation force on August 29, 2022, for a term of 6 years. Is that you?
Yes, ma'am.
All right, state.
Violated condition number 4 in Bear County, Texas. The defendant, Megan Hayes Wilhite, did then and there failed to report to the supervision officer as directed for the months of April, June, and July 2023 in violation of condition number 4.
How do you plead to that? True or not true?
Trueness.
And Judge, it's going to be on the first amended motion to revoke. It's violated condition number 1 on or about the 26th day of September 2023 in Bear County, Texas. The defendant, Megan Hayes Wilhite, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
Trueness.
Your Honor, state waives all the violations.
Any objection?
No.
All right, did you understand by pleading true to violations 4 and 1, the court could find it true, grant the motion, and sentence you up to 10 years in prison? Did you understand that? And up
This is the moment her entire argument collapses under cross-examination. After claiming she needs treatment now, she's confronted with a critical fact. Outpatient treatment was already ordered for her as a condition of her original probation. First, she tries to suggest it wasn't available, but then she backtracks and admits the real reason she didn't go. She didn't have the time because she was working. The judge immediately latches onto this contradiction. The defendant is essentially admitting that she prioritized her job over the court-ordered treatment that was supposed to be the foundation of her rehabilitation. Her credibility is shattered. She had her chance to get help and she chose not to take it, making her current plea for treatment look less like a cry for help and more like a cynical legal strategy.
to a $1,500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 1?
Yes, ma'am.
Court will find violations 4 and 1 true. Is there a proposed agreement?
No, Your Honor, we were going to go open to the court. The state was going to recommend 6 years TDC.
All right, so the state is asking for 6 years defense.
Megan, you understand the state is recommending that you go to prison,
Yes, sir.
and you're asking the court to send you to safety.
Yes.
Why?
I want the opportunity. I haven't been able to get any kind of help when it came to drug rehab, and I really do want the opportunity to be able to get clean. I think it's about time that I do something good with my life, and I believe that safety would be a reasonable option for me to be able to get clean and do the best I can for myself and my family.
What is your drug of choice?
Marijuana and methamphetamines.
Okay, when did you first start using marijuana?
When I was about 14, 15,
When
and
did you start using meth?
methamphetamines about 32 years old,
How old are you now?
38.
Have you ever received any type of outpatient or inpatient treatment?
No, sir.
In regards to the reporting, you didn't report for those months. Why?
I did not have a vehicle and I had my belongings taken from me, from an individual that I was living with, my phone, everything, all of my email addresses and everything had been changed up. I had no way to contact anybody. And I was just scared to go up to the probation office at that point. I already knew that I had MTR'd and I was just scared.
You understand that you could have gone up to probation at any time and they would have helped you and probably assisted you in getting your identification and that type of stuff, right?
Yes,
Okay,
sir.
but you didn't do that, right?
No, sir.
So you were placed on probation when, like last year in August?
Yes, sir.
Okay. You didn't receive any type of treatment?
No, sir.
Okay. And so you're asking for it because you don't want to use methamphetamines.
Most definitely not.
Passwords.
State, any questions?
Just a couple, Your Honor. Ms. Wilhite, you did have an opportunity to review the court summary, is that correct?
Yes, sir.
And did you see here that this isn't your first MTR?
Yes, sir.
And isn't it true that at the last MTR, you were told to go to outpatient treatment and that was a part of one of the conditions?
Yes, sir.
You didn't go.
I don't think that the outpatient was available at that time. They had told me that I was taking classes, but that wasn't, I guess in the, how would I explain this? They had me doing certain things at a certain time and I'm sorry, the outpatient wasn't at that time that I was going. I was going to classes downtown, but it wasn't treatment at that time.
Pass the witness, Judge.
No further questions.
I have a question. What classes are you saying you were going to downtown?
I was going to the theft classes.
All right, so what are you saying happened with outpatient treatment?
I hadn't gone to the outpatient treatment yet.
All right, why not?
I had been working and I didn't have time to do it at that time. I hadn't been able to make time yet.
All right, so this is what I'm trying to get to. 1, was outpatient treatment ordered for you? Yes or no?
Yes, ma'am.
All right. did you do outpatient treatment? Yes or no?
No, ma'am.
What is your reason for not doing outpatient treatment?
I was, like I said, I was working at the time. I didn't have the time at that period of time. I was gonna be making time for it, but I did not have the time at that period of time.
All right. Because, and the reason why I asked that question, because, and if I'm wrong, everybody can let me know I'm wrong. I'm gonna take that as a sign of disrespect. But it seems as though you were saying that outpatient treatment wasn't available when the state was questioning you. Did I hear that incorrectly?
No, ma'am, no, not that it wasn't available. It's whenever I was with Miss Martha Reyna, we were setting everything up. She had me doing the classes at that time, and I hadn't been able to do the outpatient treatment yet. Not that it wasn't available, because it was part of my agreement, but it just, she had me doing the classes. I was checking in and everything like that with her, doing my UAs and everything. I just hadn't done the classes yet for the outpatient treatment.
Okay. All right. Any other questions?
No, Judge.
No, Judge.
All right, probation.
Yes, Your Honor.
What is probation requesting?
Your Honor, the recommendation on the court summary is if she is not revoked, then to send her to safe P. I would like to point out this is her second MTR. And as she stated, it looks like she may have maybe entered the theft classes, but they were never completed.
Okay.
So at least we don't have record that they were complete.
All right. Anything else from either side?
Just brief argument, Judge.
All right, then I'll hear arguments. State you are requesting 6 years.
Yes, Judge.
Is there anything you wish to add?
Judge, it's just, she's been given plenty of opportunities to attend treatment. Even when answering the questions on treatment today, she didn't really give an answer, other than she didn't have the time to do it. She's been given chance after chance. That's why the state's recommending time in TDC.
All right, defense.
Judge, the purpose of probation is to rehabilitate individuals. I understand this is Ms. Wilhite's second MTR, but if she's given an opportunity in safety and she's able to no longer use methamphetamines in the future, then that's the win, that's the purpose. And if safety is successful, then she'll be able to complete the rest of her probation. If it's not successful, she'll be back here and you send her to 10 years TDC. So we're just asking for that opportunity to try to get her to treatment, so she doesn't continue to use methamphetamines.
All right. Anything else from you, Ms. Wilhite?
No, miss.
All right, Ms. Wilhite. The problem is, it appears that you have started things, but you have finished nothing. And the problem is, you were given a chance at outpatient treatment and you didn't take advantage of it. I could understand if you did outpatient treatment and it wasn't working. And everyone who comes into this court who's on probation, know I always say, if there's an issue, if there's something you have a problem with, if you feel probation isn't addressing it, you can always come to the court and say, Judge, this is not what they're addressing. I have a drug problem. Can you help me with that? Judge, I have mental health issues. Can you help me with that? We have an open door policy here. You can always come in and ask for that. But you haven't taken advantage of that. I'm going to grant the motion and revoke you. The state is asking for 6. Defense, what are you requesting?
Judge, we're asking for 4.
All right, I'll sentence you to 5 years in the prison. Give you credit for any time served. Is there still restitution owed? Because there were several people that
Yes, ma'am.
restitution was to be paid to.
Yes, ma'am.
So did they ever put in any amounts of restitution that were due?
Honor. No, ma'am.
All right, so they didn't put in any amounts, so I don't have any amounts, and if they want to do something with that later, they will have to take it up as a civil matter or somewhere else, but this court is not going to put it in the orders because I don't have anything. There's still to be no contact with the complainants that are previously listed. All right, so our order, therapeutic community. You're still going to have to ask for it, okay?
Yes.
All right, is there anything else?
No, ma'am.
That's it, Judge.
All right, good luck to you, okay?
In the end, the excuses ran out. The judge, having witnessed the defendant's pattern of starting things but finishing nothing, makes the final call. The motion is granted, and Megan Wilhite's probation is officially revoked. After being given every opportunity to get treatment and abide by the court's rules, she failed to follow through on any of it. The judge sentences her to 5 years in prison, a direct consequence of squandering the second chance she was given from a Christmas-time burglar, pleading for mercy to a repeat offender whose story is no longer held up. Her journey through the justice system ends with a prison cell. What did you think of the judge's decision? Was 5 years the right call? Let us know your thoughts in the comments below and subscribe for more courtroom breakdowns.